Depending on where you are farming in Washington State, having legal access to water for irrigation and livestock can make or break an operation. And unlike many other parts of the United States, the laws governing surface and groundwater usage in Washington are complex, fraught with challenges and confusion, and very often misunderstood. During a recent Cultivating Success course, one evening was devoted to the topic of water rights in Washington State. Topics included water right certificates, permits, and claims, exempt wells, instream flow rules, how you can change or lose a water right, and what it takes to secure a water right. Our speaker is John Rose, Water Resources Program Manager for the Department of Ecology's Northwest Regional Office in Shoreline, Washington.
This is an introduction to water rights in Washington State. And I'm going to start off with a bit of a historical background and overview of how water rights have developed over the past basically century. Second of all, I'm going to be covering definitions of what is a water right certificate, what is a water right permit, what are water right claims. I'm going to be discussing what permit exempt wells are and how they relate to water rights and water usage. I'm going to be discussing the ever contentious in-stream flow water rights, or in-stream flow rules is what they're formally called. And then I'm going to be talking about the criteria of what ecology uses, or the criteria ecology uses, to determine whether an application for a new water right or a change to an existing water right can be approved or not. I'm going to be talking about how water rights can be relinquished or abandoned. In other words, they lose their validity. And then finally, and will probably be interspersed throughout the entire presentation, I'm going to be talking about existing and future challenges for water rights and what they mean for you guys. So let's start with, why should anybody care about water rights? And it's very simple. For agriculture, it is the lifeblood of what farmers do. If a farm or a farmer does not have legal access to adequate amounts of water, then they face a real challenge. They face legal uncertainty, they face economic uncertainty. So understanding what water rights are, what water rights a property does or does not have, how to obtain new water rights, what is the current status of a water right, all these things are really critically important. The other thing is, our state waters are a public resource. And we need to maximize their beneficial use for the public. We need water rights to thrive, regardless of what your enterprise might be. Municipalities need water rights, farms need water rights, individual property owners need water rights, commercial enterprises, that sort of stuff. Water law is also quite complex, and it's because water is constantly in motion. It's constantly in motion between our oceans, our atmospheres, our surface water sources, the ground, and that very movement and the fact that we can't say that these water molecules belong specifically to one particular person means that it is always complex. It doesn't matter whether you're in Washington State, Hawaii, Italy, South Africa, wherever you go, because of the movement of water, it lends itself to this complexity. All right, so one of the constants about water resources in today's world is we are facing increasing competition over this limited resource. And it is a limited resource. Approximately 97% of all the water on the earth is saltwater in the oceans. And of that 3%, only approximately 14% of it is groundwater, and less than 1% of it is actually surface water. The rest of it is caught up in our glaciers, ice caps, and this sort of stuff. So it is a limited resource, and we need to be able to ensure that we manage it for a variety of different purposes, including human uses, which is, for you folks in the audience, the biggest issue is irrigation. And irrigation, by volume, is the greatest human usage. It's not domestic use, it's not commercial use, it's actually irrigation. And as you can see from this chart, we are facing an increasing population in Washington. By 2040, we're going to have another 1.5 million residents, all of whom are going to need some sort of water. But the other thing is we live in an area where we have a very large fishing commercial interests. It's estimated that agriculture brings in about $10 billion annually into Washington state. Our recreational commercial fishing industries also bring in somewhere between $5 to $7 billion. So we need to support that. And we can't if we're not allocating enough water for a sustainable environment. And that brings me into that third slide on this, and that is we do need to focus on having a sustainable environment. So managing water is really critical for today and for the future. Okay, so why do we need water rights? Well, it's required by law, but we need it to ensure proper allocation and management of those water resources. And what these water rights do is they establish priority dates, which can be used to allocate water during times of shortage, during times of such things as droughts. And I'm going to be talking a lot more about priority dates and allocations throughout this presentation. So it's ecology's role to be the manager of our water resources in the state. We administer those water rights. We are the regulator not only of the water rights, but also well construction, dam safety, instream flows, which I'm going to be talking a lot more about in this presentation. And under certain circumstances, the legislature can direct us to be a supplier or developer of water. I'm going to talk a little bit about the science of water movement, what we call the hydrologic cycle. And it being a cycle, you can start anywhere on this presentation, but typically what we do is we speak about water that's in the ocean. Near the surface, of course, it's warmed by radiant energy from the sun. The water becomes vapor, it rises up into the atmosphere, condenses as clouds, and then air currents move those clouds over the surface of the earth where it falls as precipitation. And that precipitation can be either as snow, hail, or rain. Once it does strike the surface of the earth, it typically has three different fates. It either evaporates off the surface or transpirates through plant uptake. It either runs off as surface water runoff and feeds into our streams, rivers, and lakes, or if it reaches down below the root zone, it becomes groundwater. And that groundwater will flow very, very slowly on the order of a few meters per year, but it will still flow under the force of gravity either to a deeper aquifer or it'll discharge to a surface water source. And by the way, this is a really good time to mention what an aquifer is. It is a body of groundwater, so it's sitting in between the soil particles. It saturates the area in between the soil particles, or it exists in the faults and fractures of bedrock, and it's of enough quantity to be extracted and used for human uses. Okay, so moving into how water law has evolved in Washington state, around 1850, we begin to see Western or European development of Washington state, and up until 1917, we were following a doctrine of water use called the riparian doctrine, or riparian use. And the idea behind riparian use, and it's kind of hardwired into our minds, is the idea that if water is on, below, or adjacent to your property, you're free to use it as long as you don't impair access of water to your neighbors. And that was a policy, or excuse me, a doctrine that was used right up until 1917, when we adopted our first water code. The reason why we abandoned the riparian use was because it simply didn't work in the western parts of the United States. In fact, there's no western states that actually follow the riparian use, because once you move west of the Mississippi River, the United States becomes more arid, water becomes less available, it's less evenly distributed. And the assumption of the riparian doctrine is that there's sufficient water on people's property to meet their needs. But if you're a 19th century cattleman or 19th century large mining enterprise, that may not always be true. And so what we found was the riparian doctrine was breaking down. And so in 1917, we adopted this prior appropriation use, which I'm going to be talking about throughout this presentation and define in a later slide. But up until 1971, all this effort of water use was focusing on allocation of water for human uses. Now, 1971 is somewhat of an arbitrary date. It's actually the date when the Water Resources Act passed in Washington state. But after the 1970s, we realized that we needed to ensure that there was enough water remaining in our ecosystems for environmental sustainability. And so we began to transit to this model of environmental sustainability, and it's a transition that we're still going through today. And water has always been contentious. And as we transition to this model of environmental sustainability, it means that we are increasingly seeing, along with that increasing competition in water, increasing conflict. Okay, a little bit more about the historical background of how water policy is developed in Washington state. We follow the concept that water is owned in common in Washington state, and that is an idea that has been around since Roman times. And so we as Washingtonians own the water in common. The federal government basically devolves authority of water management to the states. They can step in and reserve water for themselves for specific purposes. That might be for forest practices. If it's on national forest land, it might be for military bases, that sort of stuff. But for the rest of it, it's managed by the state. Western Europe and the Eastern United States adopted the riparian doctrine that I just described, but we found, like I said in an earlier slide, that simply didn't work for us, and so we adopted this prior appropriation doctrine. So here's two gentlemen sedately discussing their water rights over their shared irrigation ditch. This is the time to laugh, guys, because this is as funny as I can make it. But it really is central. It really is a fact that people argue over water all the time. And as Mark Twain said, in the West, whiskey is for drinking and water is for fighting over. So I'm going to step aside a little bit from what I've been talking about, and I'm going to ask a rhetorical question here. In this hypothetical situation, I own a piece of land and I plan to build on it when I retire, and I had a well drilled on that property 5 years ago. Do I have a legal source of water? The answer is not necessarily, okay? And the reason why I ask this question, and I want you guys to think about it, is because it's central to one of the basic tenets of water law. And when we created that first water code in 1917 for surface water, it established that a water right is only vested or only created when that water is put to beneficial use. In other words, it's put to the use it's intended for. So you can own the land, you can have a well, you can even have a house on it or a commercial enterprise, but that water right isn't vested until you put the water to beneficial use. And if you need to acquire a water right for it, you need to have that legal authorization to do so first. Let's talk a little bit about our first water code and what the principles are behind it. So our first water code came in 1917. And it adopted the idea of prior appropriation, which I've already been talking about. And it's mortalized in this phrase, first in time, first in right. I think the best way of describing what prior appropriation means is to give an example. So for instance, let's say I own a water right. I acquired a water right from the state in 1950, and it allows me to use 100 gallons a minute pumping rate and 100 acre feet per year in terms of annual volume. My neighbor comes along in 1980, 30 years later, and they acquire a water right for the exact same amounts. Now, under the prior appropriation, because I established a water right first, I have a senior water right. And that means I get all the water that has been allocated to me first before anybody junior or who established a water right after me does. So in times of a drought or in times of shortage or in times of conflict over water, I'm going to get all that water first before anybody junior to me does. And so my neighbor if there's not enough water for the both of us, may not be able to get any water at all or only get a small amount of that. This was really illustrated very well in 2015. Most of you may recall we had a tremendous drought in that year. Over in the Kittitas Basin, all the water had already been allocated by 1905. So 12 years before we even had our first water code, the state recognized that all the water had already been used, or I should say, had already been allocated for various uses. And so in 2015, when the drought happened, all those folks who had established water rights, informally established water rights, prior to 1905, got all their water, but only 47% of those people who established water rights after 1905 got their water. Okay, so it established that prior appropriation principle. It also said that for surface water, all new uses of water needed to acquire a permit from the state. Okay, and for surface water, there are no exceptions. So what does surface water mean? It means that if the water daylights before you start using it, then it's surface water. I can't tell you how many times somebody's come to me and says, well, I'm using groundwater. And I said, okay, well, what's the source? And they say, oh, it's coming out of it's a spring. I said, well, that's not groundwater, that's surface water. They said, but it's coming out of the ground. And I said, yes, but it's surface water because it daylights. It actually comes out of the ground before you're using it. It also established that existing water rights were protected. So prior to 1917, to actually acquire a water right, all you had to do was to post a sign at the point you were diverting water from, saying, John Smith has acquired 100 gallons a minute and 20 acre feet of water out of the Kittitas River. Let's say that was it. And all they had to do was record that with the county assessor's office. This created a huge amount of controversy, conflict, and confusion. And so when we established the surface water code, we recognized the fact that folks had established these informal water rights and protected them. And I'll talk more about that when we get to water right claims. It also said that a water right is pertinent to a specific piece of land, to what we call a place of use. And so you just can't pick it up and move it without getting authorization from the state. A water right is considered superior to a groundwater right. So if all other things are equal, if I establish a water right on January 1st, 1950, and it's a surface water source, say it's from Lake Whatcom, and my neighbor establishes a water right from a groundwater well on the exact same date, if there's conflict over those two water rights, because I have a surface water right, I'm senior. Notice I've put this in red, guys, and in big, bold letters. You cannot create a right through illegal use. Now, I actually like to refer to this as non-legal use because it implies people are being criminals. But the point behind this is, unfortunately, in Washington State, we have a lot of people who needed to acquire a water right or a permit from the state and who never did so. And they have created a business, be it a farm or a commercial enterprise, and they may have had this operation for decades. It may have been passed down to their sons or daughters, but they never acquired a water right. And they come to us all the time and said, yes, but I've been using this water all the time, therefore I'm grandfathered in. And with one exception, which I'm going to cover when we talk about water right claims, the answer is no. Okay, so if you're somebody who's looking to purchase a farm or purchase a commercial enterprise and what have you, it really behooves you to do your research to find out whether property has a water right. And I'm going to be talking about some of the sources you can go to find out whether it does or doesn't. Okay, so in 1945, we established our groundwater code, okay? And the reason why we didn't create a groundwater code in the same time we created a surface water code was because prior to the 1940s, the technology really didn't exist for really deep wells. Your groundwater wells prior to that were mostly dug wells. In fact, they were almost exclusively dug wells, and they only went down about 30 or 40 feet. But by the 1940s, you had the drilling equipment to allow you to economically construct deep wells, relatively inexpensively, relatively rapidly, and we began to see a profusion of these groundwater wells. And so the legislature determined that it was necessary to have a groundwater code to manage those as well. And they made it supplemental. The groundwater code became supplemental to the 1917 surface water code. So the same ideas that were in the surface water code applied to groundwater. Namely, prior appropriation was also adopted for groundwater, okay? New uses also needed a permit. So if you're going to drill a well, it was a groundwater source, you needed to acquire a permit from the Department of Ecology or its predecessor agencies. However, they also included an exemption from acquiring a water right permit for small uses. We call these permit exempt wells. I want to stress that there is not an exemption for surface water. If you are using surface water, you must have a water right or a water right claim from the state. But if you're going to be using groundwater from a well for small water uses, and I'm going to explain what those are, you may not need to have a water right. Okay, these are called permit exempt wells. So, what are those exemptions from needing a groundwater right? Well, one of them is livestock. If you're using water to provide for livestock, that's cattle, horses, goats, sheep, chickens, that sort of stuff, you don't need a water right for direct feeding of the animals. Now, as it turns out, there are some animals that don't fall under the definition of livestock. Livestock is basically defined as those animals that have traditionally been used in agricultural practices or for the creation of agricultural products. We had a court case where somebody argued that it was a mink farm, as it turns out, and they were arguing that they didn't need a water right for mink. And as it turns out, they lost that case because it doesn't fall under the typical definition of livestock. One of the things to point out is there is no quantity limitations for livestock, and that was resolved in the Supreme Court case just a couple of years ago. But you can use unlimited amounts of water for livestock. Now, if you have a commercial operation associated with livestock, if you have 30,000 heads of cattle, for instance, and you're using processed water for, say, the cooling of milk, that might require a water right if you're using more than 5,000 gallons per day. And that's because there's also a commercial exemption. I'm going to go into that in the next couple of slides. You can also use water from a well for single or group domestic use as long as you are not exceeding 5,000 gallons per day, okay? And since this is used so often, I'm actually going to repeat myself here. If you're using water from a well for single or group domestic use, as long as you're not exceeding 5,000 gallons per day, you do not need a water right from the Department of Ecology. Now, there's been some recent changes. Some of you may have heard of the Hearst case. This was back, I believe, in 2016. And it was a case that was up in Whatcom County, and it cast into doubt whether people could still rely on these permit exempt wells for domestic use. And it took the legislature quite a few years, 2 years, excuse me, to resolve this issue. But when they actually did come up with a bill that would allow people to have legal certainty on using water from a well for domestic purposes, they actually included some limitations. So depending on where you are, while you can use up to 5,000 gallons per day for single or group domestic use, on an annual average, you may not be able to exceed 3,000 gallons per day or 950 gallons per day. And I want to repeat that. So you can use up to 5,000 gallons per day for single or group domestic use, but there may be an additional limitation that the annual average use cannot exceed 3,000 gallons per day or 950 gallons per day. The legislature also said that you do not need to acquire a water right for groundwater use for industrial uses industrial uses as long as you do not exceed that 5,000 gallons per day. All right. So agricultural use falls under the definition of industrial or commercial uses. So if you're a small-time farmer and you can rely on a groundwater well and not exceed 5,000 gallons per day, you do not need to have a ecology-issued water right. And finally, the last provision of the permit exempt well clause is that if you're irrigating half an acre of non-commercial lawn or garden, you do not need to have a water right. There may be additional restrictions in certain areas on this in regards to what I'm going to cover later in this presentation, in-stream flows. For instance, if you're in the Still-Squamish Basin, that you're actually restricted to 1/12 of an acre. In other parts of the state, it's for indoor use only. It doesn't allow for non-commercial lawn or garden. That's where you want to check with county planning folks or to contact Department of Ecology. All right, so I've been talking about water rights throughout this whole presentation so far, but let's define it because I haven't actually told you what one is or what the official definition of a water right is. And so a water right is a legal authorization to use water for a beneficial use of a reasonable quantity of that public water during certain periods of time and that occurs at a certain place. And this is really critical to understand because many people in the past have assumed that once they got a water right, it's kind of a blanket use to use water. And they either ignore or they forget that there's quantity limitations on that water right, and they go off and expand their water use, not realizing that they have certain limitations on it of where they can use it, what time they can necessarily use it, what quantities they can use it for. So it is a limited right. It's not just a blanket right. All right, so on any water right certificate or document, and we'll be talking more about the various documents in a later slide, you have certain information that's on it. It's going to tell you a point of diversion or withdrawal. In other words, where's that water coming from and what type of water source is it? It's going to tell you the purpose of use, place of use, priority date, period of use, instantaneous rate, and annual quantity. A point of diversion, for instance, is for surface water. And there's a picture of what a very large surface water diversion is. A point of withdrawal is the term of art we use for a groundwater well. And on that water right document, it's going to tell you exactly where that well is located or where that point of diversion is located. It's going to tell you if it's a surface water diversion, what's the body of water it's pulling from? Is it from the Skagit River? Is it from Lake Whatcom? Is it from the Still-Squamish River? If it's from a groundwater well, it's going to give you the location of that well. It's going to give you a distance and direction from a known point. A water right is going to tell you the purpose it's intended for. I've listed three of the most common ones: irrigation, stock watering, and domestic, or both single and multiple use. I just recently said, of course, in an earlier slide, that stock watering doesn't require a water right. But that was only resolved within the past couple of years. Because of confusion in the language of the water code, that was not very clear until about 2010. So in older water rights, it might actually list stock watering as a purpose. But there are many other purposes as well: power generation, commercial use, fire suppression, fish propagation. The list goes on. And one thing to point out to the audience here is that a water right can have multiple purposes on it, and it can assign specific quantities of water to those purposes. So a water right might be for domestic irrigation and power generation. It might list all three of those, and it might say that 10 gallons a minute and half an acre foot per year is reserved for domestic use, 50 gallons per minute and 20 acre feet per year is for irrigation, and then some other quantities for, say, that third purpose, power generation. The water right is also going to have a place of use. That place of use tells you where you can apply the water to, and it usually consists of a legal description from a land survey. And it's going to look something like this. Hey, you know, farm A can irrigate this field. And that's really important because we're going to be talking about transfer of water rights later on in this discussion. Okay, so additional information on the water right, it's going to have that priority date. So What is the priority date? Well, it's the date an applicant files an application with the Department of Ecology or its predecessor agencies. So if you're looking to acquire a water right, you're on, say, on Whidbey Island, and you file that water right today, the day it reaches our office is going to be its priority date. It's not when we actually approve the water right application. And that puts you in that hierarchy of water rights. So if you're on Island County, you get a water right for March 24th, 2020, and somebody comes along and gets a water right the following year, they're going to be junior to you. So it's, as I just said, it's where you are in the hierarchy of water allocation. The other thing is that water right is going to tell you when you can use that water, when you can turn on your water. Some uses, like domestic use, municipal use, they're going to be for year-round, but for irrigation, they will not be. These are called seasonal water rights. Older water rights will say that the water right is can be used during the irrigation season. It doesn't provide any actual dates. But newer water rights will actually give you the dates of when you can use it. Typically what we use is May 15th to October 15th as the dates you can use it for a seasonal irrigation water right. So an irrigation water right, just to reiterate, is not for a year-round use. Okay, and of course, finally, and most importantly, there's going to be quantities of water that will be allocated to you that you can't exceed. Okay, the first one is going to be an instantaneous rate. It's your pumping rate, and it can be listed either in gallons per minute if you're drawing from a groundwater source, such as a well, or it's going to be in cubic feet per second if you're drawing from a surface water source. Just to let you know, 1 cubic foot per second is equal to 448 gallons per minute. The other thing is it's going to have an annual quantity, a total volume over the year that you cannot exceed. And that's always listed in acre feet per year. 1 acre feet per year is the amount of water that fills 1 acre to a depth of 1 foot and cannot be exceeded, total volume cannot be exceeded over 1 year. That is equivalent to 325,851 gallons. And I'll just repeat that. 1 acre foot per year is equal to 325,851 gallons. All right. So there are various different types of water rights, okay? What you hope you have on the property that you've just acquired or it's been passed down to you or you're looking to purchase is a water rights certificate, because that is the final document that you acquire after going through the lengthy and, in some cases, a very expensive process of acquiring a water right. It is issued to a landowner after they've already been approved for the water usage through a permit. They first acquire the permit, but that permit is only to allow them to build into their water right, to build all the infrastructure, to put that water to beneficial use as intended, to use all the quantities of water that they need for their project. Once that is all done and you indicate to the Department of Ecology that you've done all that process, you get the water rights certificate. And the power of the water rights certificate, guys, is that it's good in perpetuity. Think about that. A water rights certificate, as long as it's still valid, it hasn't been relinquished or abandoned, and we'll talk more about that, is good in perpetuity. Not every state does that. A friend of mine, one of my coworkers, used to work for the Pennsylvania Water Commission, and every decade they would review people's water rights and determine whether they still needed that water. And if they didn't, or they didn't need all the quantities of water that had been allocated for them, that water right would relinquish. So in Washington State, water rights certificates can be very, very, very valuable. Now, I've already talked about permits, and so I won't cover that too much more in detail, but the water right permit is issued once we decide that, yes, we can approve your water right application and that you're now free to develop that water. But it's not the final water right certificate. And unfortunately, all too often in the past, we try and avoid this by communicating with our water right permit holders. a person gets the water right permit and they think they're done. They think they've got their water right, that they don't need to do anything more action, and we never hear from them. And if we never hear from them, we may have to cancel that water right permit because they haven't done everything to secure that final water right certificate. All right, now we come into the very difficult issue of water right claims. So as I mentioned earlier in my presentation, prior to the water code coming into place, either 1917 for surface water or 1945 for groundwater, people were still acquiring water rights. They were just doing it very informally. Well, in the 1960s, late 1960s, early 1970s, the legislature opened up a water rights claims registry. They wanted to basically have documentation for all of those informally established water rights. And they invited landowners to submit claims if they believed that they had begun using water prior to 1917 for surface water, prior to 1945 for groundwater. Now, the intention was that they would then adjudicate these water right claims. There would be a formal process, a court process, that would determine whether these claims are valid or not. And that is unfortunately still something we are still undergoing. It has been a very long, slow process. We have focused primarily in eastern and central Washington because it is a much more arid part of the state. It's a much more agriculturally developed part of the state, and that's where we need to really focus our efforts. But in most parts of western Washington, those claims have not been validated or not. So we don't know whether these claims are legitimate water rights or not. And they pose a real headache for trying to manage water where we have numerous claims. The ecology's principle or its stance on water right claims is if you have a claim, we are not going to contest it. But if an adjudication of water right claims occurs in your area, the court may ultimately rule that that water right claim is not valid. All right, so then we have instream flow water rights, and these are issued to protect rivers and stream levels. They're basically water rights for the ecosystem, and I'm going to say no more about those right now because I've got some additional slide or two on in-stream flow water rights in and of itself. You're a property owner over in San Juan, the San Juan Islands, and you want to obtain a new water right. What is the criteria that ecology uses to determine whether we can approve a water right or not? And we call this the 4-part test. If you want to obtain a new water right, the use that you intend to use it, whatever you intend to use it for, must be considered beneficial. Now, fortunately, that's usually a no-brainer. If you're using it for stock watering, irrigation, domestic use, the 3 big ones, commercial use, power generation, all these are considered to be beneficial. But every once in a while, we do get a water right application where we determine it is not beneficial. We had a gentleman, 15, 20 years ago, who developed these enormous water bladders. And he intended to fill them up and have these water bladders towed to the Middle East to provide water to places like Saudi Arabia and such. And because he needed to establish a well field to and draw water from wells to fill these bladders, he put in an application for us, and we actually turned him down. We said, look, the water is for Washingtonians. It is owned in common by Washingtonians. It is not intended for people outside of Washington state. So in addition, the water that has to be available, it has to be legally and physically available for us to issue you a water right. And this is the tough part. This is always the toughest part of determining whether a water right application can be approved or not. Determining the physical availability of water requires a hydrogeologist. Okay, I am a hydrogeologist. Hydrogeology is the study of groundwater, its movement, occurrence, and quantities. And nowadays, if you're going to get a water right application approved, you must have a hydrogeologist do a scientific study to determine the physical characteristics of the aquifer beneath your property. And so acquiring new water rights can be very, very expensive because of this requirement. The other thing is the water has to be legally available. In other words, the water cannot have already been allocated for other purposes. And this has direct relationship to our in-stream flow water rights, which I'm going to be talking about later. The water rights application or the intention of using that water cannot be detrimental to the public interest. This is a very broad category. It can mean a variety of different, it can mean a variety of different things. One of the most common reasons why we might not consider that the water use is in the public interest is if you're putting a well in a coastal area and it might cause what we call seawater intrusion, where you're actually pumping on the aquifer and that's causing salt water to contaminate the aquifer. But there are other reasons why we may not be able to approve a water right application because of public interest. And then this new water right that you're hoping to have to be approved, it cannot impair existing users because of the prior appropriation principle. Okay, the other thing to keep in mind is because we're talking about water rights, this is a very open process, and anyone can appeal a decision on whether we approve or deny a water right because they may believe that that new water right might impair their existing water rights. They might impair what they believe is water quality issues. They have that right to actually protest it. Okay, so when we're considering a water right application, there are other things we look at. There might be existing watershed plans. Watershed plans are for each individual watershed. They exist in various parts of the state. Not all watersheds have them, but it's basically a local management plan for water. They may have additional restrictions that would prohibit us from approving a water right application. There may be stream closures, there may be in-stream flows, which I'm going to be talking about in a later slide. If you're using or applying for significant amounts of water, this might trigger a state Environmental Protection Act review. There might be site-specific considerations. I mentioned the seawater intrusion issue. That would be considered a site-specific consideration. And there could be other things as well. So I've been mentioning in-stream flow rules or in-stream flow water rights. The terms are used synonymous. Now it's time to really talk about them. And this is the largest limiting factor for acquiring new water rights, or sometimes for changing or transferring water rights we have in the state. Remember in the earlier slide, I talked about us transitioning to a sustainable resource model. How we do that is through these in-stream flow water rights. And what a water right, or what an in-stream flow water right is, it's a water right for an existing ecosystem or watershed, or for a river basin. Watershed and river basin, you can use those terms pretty much synonymously. And it's meant to protect aquatic and wildlife habitat, water quality, recreational values, and navigation. I never really thought too much about the whole navigation part of it until 2 years ago when I had a chance to take a trip down the South Fork of the Skagit River. Each one of us hydrogeologists are assigned a specific river basin, and the Skagit is mine. And I was really surprised. We are on a rising tide. That part of the river is actually tidally influenced. And I was surprised at how shallow it was. It was the height of the summer. It was during a time when you had significant amount of irrigation going on. And keep in mind, groundwater and surface water are the same resource. And so when you're pulling on those wells, when you're drawing water from those wells, that has the potential for drawing down your surface water sources. And our boat, which was a pretty small one, almost ran aground on this in this South Fork of the Skagit River. And this is the third largest river on the west coast of the United States. So we do need to preserve things like navigation, recreational values, in addition to what appear to be oftentimes more important values such as water quality and wildlife and aquatic habitat. So how do we set these in-stream flow water rights? We do it through a scientific study and bringing in stakeholders. And what we do with that scientific study is we set minimum flows for that river. Okay, so for example, on the Skagit River, Minimum flows during the summer months is 10,000 cubic feet per second of flow. All right. So this being a water right for the river basin, the Skagit River in-stream flow rule was set on April 14th, 2001. If you are acquiring a water right, both surface water and groundwater, because we recognize legally the connection between the two, and you establish it after that date of the institution of the in-stream flow rule date, that April 14th, 2001, it means you're acquiring an interruptible water right. And I want to make sure this is very, very clear to my audience here, because this really limits future water rights. I would just use an example, and I'll just kind of reiterate the Skagit River. In-stream flow rule was set on April 14th, 2001. Somebody comes along and acquires a surface water right from the Skagit River in 2003. When those minimum flows that are established in the in-stream flow rule are not being met, that means that they cannot use their water right. And when you think about it, typically our flows drop during the summer months. That's at the time when irrigation is most needed, but there may not be enough water to be provided from the aquifer or from the rivers because those flows are not being met. And finally, in-stream flows are equal to all other water rights. I can't tell you how many times people have come to me and said, well, I'm going to be using this for water for domestic use or stock watering or irrigation or power generation. And surely that's more important than preserving flows for an ecosystem, for a river basin. The state doesn't recognize that. All uses are equal. Any water right issued after an in-stream flow rule is junior to that in-stream flow rule, as I was iterating earlier. A water right can be lost, okay, due to non-use. This is called relinquishment or abandonment. And this is really important to understand. We call it use it or lose it. So for my audience tonight, there's three ideas. If you don't learn anything more, I want you to come away with. One is prior appropriation. In other words, first in time, first in right. Second of all, a water right is only vested or created when the water is put to beneficial use after you get authorization to use it. And finally, this principle of use it or lose it. I can't tell you how many times we've learned somebody has lost a water right due to non-use. It could have been avoided if people understood the rights and responsibilities of being water right holders. So how does this work? Well, a water right can be relinquished if that water right or portions of that water right in terms of its quantities are not used for 5 or more consecutive years. So I think an example is really useful here. Let's say I'm a water right holder. I'm entitled to use 100 gallons per minute and 20 acre feet per year. And 10 years ago, I went from growing berries to dryland wheat. And so I reduced my water use, and I was only using 50 gallons per minute and 10 acre feet per year. And now I want to go in and I want to change that water right. I want to transfer it, and I go into a Department of Ecology, and we say to you, oh, look, I'm terribly sorry, but those portions that you weren't using have been relinquished. We don't really want people to face that situation. We can work with you to avoid it. We have something called the Trust Water Right Program. And basically it means you can bank that water that you're not using, you can put it temporarily into trust. But unless you contact us and you don't take any actions when you reduce your water use, you could potentially lose it. So I strongly urge people to understand that portion of the law and what you can do to avoid it. It's always painful to have that conversation with people when we realize that they may have, they're facing relinquishment. The other thing is abandonment of a water right. And that is where an entity had a water right and they clearly not only stopped using it, but they stopped using it in a way that clearly indicated they never had an intention to ever use it again. And I have a really great example of this. Back in 2015, during the drought, we got contacted by the city of Bellevue, and they said, we have these water rights from the 1950s, and we want to reestablish them. So we started looking under the hood, so to speak, and we discovered that these had been on a well field. A well field is simply a collection of groundwater wells. But they had torn out all the wells, all the well casings, the pumps, the infrastructure, and then they had turned that property into a shopping mall. That's clearly an intention never to ever use that water right ever again. And so we said to them, we consider that to be abandonment. Now, when it comes to relinquishment and abandonment, if there is legal contention over ecology's findings, it is ecology's burden to show proof when we're facing relinquishment. But when you're facing abandonment, it is the water right holders' burden of proof to prove that they had not abandoned the right itself. This is a really good time to mention the current status of acquiring new water rights and making changes to water rights in Washington state. Because we now have in-stream flow rules throughout all of Western Washington, with the exception of Island County and San Juan County, getting new non-interruptible water rights is extraordinarily difficult. It's virtually impossible. And acquiring a new water right is going to require that you hire a hydrogeologist to do a study. It's very, very difficult, very, very expensive. For property owners who are looking to use water for agricultural uses, either you need to find a property that already has a water right, or you need to transfer a water right if it doesn't already have one. Getting a new water right really isn't practical. But we can change water rights, and the most common is doing a water right transfer. But we can change the source legally. We can go from groundwater to surface water or surface water to groundwater. To tell you the truth, this is largely no longer possible, because we've had some recent Supreme Court cases that have severely limited our ability to change the source. But it used to be that we could do that. We can change the purpose of water right. We can change it from domestic to industrial, for instance. Keep in mind, though, if you have a seasonal irrigation water right and you want to begin to use it for year-round use, that may not be possible in light of in-stream flow rules, because you would be having an impact, or potentially having an impact, on flows during times of the year when previously there hadn't been. You can change the period of use. Typically, you can go from a year-round use to a seasonal use, but you can't go from a seasonal use to a year-round use, okay? We can change the point of diversion and withdrawal. We can change its location. Let's say, for instance, that you're authorized to use well in a certain area, and now you want to change it to another area. We can do that. And most importantly and most commonly, we can change that place of use. In other words, we can transfer that water right. Okay, and that's the most common way we change water rights. People want to acquire a water right from somebody else, they do a transfer. We can also change some of the provisions on a water right. So oftentimes we will issue with a water right permit certain provisions. So if you're right next to the coast and there's a potential for seawater intrusion, we may limit the depth of the well you can construct, but we can change those provisions if there's new information that shows that those provisions are no longer valid. One thing I want to point out, and this is really, really critical, you cannot change the quantities, you cannot change the priority date on a water right. Now, when we look at a water right, and I'm going to be going into this in greater detail in another slide, we have to look under the hood and determine whether there's relinquishment. But you can't come to us and say, look, I have a water right for 50 gallons a minute and 50 acre feet per year. I want to increase that amount to twice that amount. We would say to you, no, you can't do that. You need to acquire an additional water right for that extra water you want. And you can't come to us and say, I have a priority date of January 1st, 1950. I want to change it to January 1st, 1930. That just isn't legal. Okay, so changing a water right process. The first thing we're going to do is, if we get an application, is there a water right to change? Has that water right been relinquished? Is that water right actually pertinent to the land that you claim it's for? And then, is it the proposed change allowable by law? So once we receive an application, we're going to begin an investigation to approve or deny it. And we're going to ask, is it a certificate, permit, or claim? If it's a certificate, then hey, no problem. We're going to look at whether any amounts have been relinquished, but it is a certificate. It was legally issued by the state, and there's less legal uncertainty about it. If it's a permit, you may not be able to fully change all the amounts of water on that permit because you may not yet have put that water to beneficial use. Remember, that permit phase allows you to develop into that permit, or develop into that water right and begin to use all that water. So if you're only using 2/3 of the water of the permit, you haven't used all that water, you may not be able to change all that water to a new place of use, for instance. And then if it's a claim, we're going to do a tentative determination if that claim is valid or not. And if it's not, we're going to say, oh, look, we're terribly sorry, but there's no water right to change. And then we're going to ask, how big was it originally in terms of its quantities? And has those quantities been relinquished or not? And then, is the proposed change allowable? Is it in the public interest? Will there be impairment of existing water rights? Will there be enlargement? In other words, is it going to enlarge the amount of water use, like I stated earlier? And is there season of use considerations? And then if you're changing a groundwater right, it's got to be the same body of groundwater. It's got to be the same aquifer. You can't simply pick up a water right in eastern Washington and move it to western Washington, because that would not be the same body of groundwater. And then I was mentioning earlier, we have been in the past been able to do surface to ground transfers, but unfortunately, that's no longer something that we can do at this point in time because of a recent Supreme Court decision. We're hoping the legislature is going to change that, because when we move from surface water to groundwater, we're actually being able to provide the landowner with the same amount of water, but it's going to have less impact on our streams and rivers. So it's a win-win situation for everybody. Water law, as I mentioned earlier, is very, very complex. About 2/3 of the water law is actually not in statute. It's in case law. And we have this layer cake of over 120 years of this case law sitting on top of our water law, and makes it very, very hard to understand. The other thing that makes this challenging is sometimes, or oftentimes, water law is not recognized by other laws that have relevancy to it, whether it's the Growth Management Act, Endangered Species Act, and other land use planning. If you want to put in a replacement well, that is not a problem, okay? Even if you have claims, the claims are not necessarily invalid. We just haven't been able to prove that they are valid. And ecology's policy is to treat claims as if they were valid until we are told otherwise by the court. Now, that we do have to be a little careful here. If we have a property that we can prove that has never ever been developed, and you say, and there's a claim on it, then we're going to say, look, guys, even though the court tells us that they're the only ones who can determine whether a claim is valid or not, if the water's never been used, there's no water right. Remember that beneficial use clause. But you're talking about a farm that has wells and claims on it. Go ahead and put in a replacement well. Oftentimes these wells, which are very old, are of substandard construction in comparison to today's well construction standards. They may have PVC pipe instead of steel casing. They can have degraded water yield because of silt buildup, iron bacteria buildup, all sorts of different things. And wells have a limited lifespan. So replacement wells are not a problem. If you want to transfer the water right, then you would need to submit a water right change application with us, Julian. But if it's for the exact same parcel of land, then you don't have to. What you typically do is you hire a driller. The driller will check to make sure that there's water rights on it and they're pertinent to the land that you're intending it for. And then what they do is they file with Department of Ecology what is called a notice of intent. It just tells us that you're putting in a well, and that's all. Water rights are pertinent to a specific piece of land, as I mentioned in my presentation. But smart farmers are doing the thing of where they're pooling their water rights. They come to a Department of Ecology and they say, look, we want to form a water bank, or we want to form what we sometimes call a watershed improvement district, and we want all the water rights of these shared water rights to apply to this very large irrigation area. And then what they do, once we approve that, is then they will share out the water on a per need basis. And I really think that this is a great idea. I wish farmers would get more organized to do this, because it allows them for far more flexibility than just saying, hey, there's a water right for this specific property. And it allows governing entity who's managing these water rights to lease them or allocate water depending upon the internal agreements of that improvement district or that water bank or the co-op, however it's operated. What's really nice about that is, let's say I'm farmer A, and I've been irrigating since May 15th, and I stop irrigating, say, in June 15th. Normally that water would just not be used. But if it's part of a water bank or some sort of shared collection of water rights, then the managing entity can say, oh, I can take that water and I can give that water to somebody else so that it's being used in this irrigation area. And this is really the future of how we manage water. The problem, of course, is that farmers really need to understand that this is the way to move forward with it. Yes, so we have a policy that came in 2009. Prior to that time period, when we developed our first water code, we also said that waters of the state, in other words, waters that are managed by the state, include all water on, below, and above the surface of the earth. And I swear, we must be the only state that says waters above the surface of the earth. In other words, rainwater is managed by the state. And the only exception to getting a water right is that groundwater exemption, the permit exempt wells. So prior to 2009, if you wanted to capture rainwater and use it on your property, you needed to acquire a water right. So in 2009, our policy became that rainwater catchment does not need a water right as long as you're pulling that water from the roof of a pre-existing structure. In other words, you can't build a structure just to collect rainwater. It's got to have some other use, unless you're creating what we call a guzzler. A guzzler is a specific structure meant to collect rainwater to serve livestock and livestock only.
As you have heard, there are plenty of things to consider as you seek to secure the legal usage of water on your farm. Spending the time and effort to research what rights may or may not come with a parcel and how you may or may not use a secured water right can save you money and heartache down the road. We want to thank John Rose for sharing his insights on the complex topic of water rights in Washington State. We hope you find it of value as you build your own small farm. Thank you for listening.